All right. Hey, everybody. Thanks for dialing in. I'm Varun Negandhi. I have with me Avalon Paul. I'll ask her to introduce herself. And while she's introducing herself, I would love for the audience to let us know where you're dialing in from.
Perfect. Thank you so much for having me this afternoon. I'm really excited to be here. My name is Avalon Paul. I'm an immigration attorney with Manifest. I am an immigrant myself. I came here from Trinidad when I was 5 years old. And so I deeply and inherently understand the concerns, the frustrations, the anxiety that many people on this live broadcast are having, and with my clients as well. I have been practicing attorney for about 10 years now, just over 10 years, and with a focus on immigration. And I focus specifically on all areas. So, removal defense, family based immigration petitions, and of course, employment based or business immigration. So, thank you again for having me today.
Awesome. We are extremely grateful to have you here. EB-1A and all the criteria around it are a complex issue, and there are different positions and different angles to it based on what your background is. Like if you are a tech engineer,
Mhm.
if you are a non-tech engineer, if you're not even an engineer, like everybody has a complex view of the immigration criteria. I see some questions coming in already by Siddharth, so that's great. What I will ask from the audience, I'm unable to see how many people are in there, but if you can all can just say hi and let us know where you're dialing in from, that would be great. All right, so there is Vivek KKR based out of DC. Nice. Love that Siddharth Mohan came in, or Sid Mohan came in with
Ready.
that questions energy. But I'm curious to see now where he is joining us from. A quick question also to the group who is
Yes.
live before I ask Avalon a question is, do you guys know about the 10 EB-1A criteria? I think that would be a good kind of a baseline question for us
Yes.
to understand whether you are aware. And if not, that can be the first question that we can start with. So no judgment, just curious to know if you know the 10 criterias of EB-1A. All right. Could be a lag in the system, but I think Avalon, we can
Sure.
start by maybe setting that baseline. Can you
Sure.
briefly talk about the criterias that define extraordinary ability?
Absolutely. So there are 10 criterias, and every applicant as of today must submit evidence that they meet at least three of those 10 criteria. So the first criteria is, of course, a lesser recognized award for excellence. Second criteria is proof of your original contributions to your field of expertise. Third criteria is published material about you in major media. So your quotations, your press pieces, them someone covering you, we want to see if there's something being published about you. The fourth criteria is your authorship in a medium that is specific to your field, of course, in major media as well. Fifth criteria for the artist, commercial success in the performing arts. Next criteria is being a judge of others in the field, either individually or on a panel. Next criteria, seventh, is having your work displayed at artistic exhibitions and or showcases. So conferences, panels, things of that nature. Next, our eighth criteria is membership in a distinguished association or organization whose membership relies on you having extraordinary abilities. So stay away from any association that just has a membership fee and they're not looking at your actual experience and expertise. Number nine, we have performing a leading or a critical role for a distinguished organization. And the last but not least, proof we command high salary or significant remuneration.
Awesome. So these are the 10 criterias. And if I am to understand that you need to hit three of these to qualify for an
Yes.
EB-1A, correct?
Yes, that's correct. At least three. So most applicants would like to try to submit for four, five, or even six of the categories, and then hope that the USCIS officer reviewing the case agrees that of those four, five, or six, that they meet at least three of them.
Awesome. Before we get into the nitty-gritty, and there are some really good questions already, I'd love to ask that any EB-1A application is highly individualized and specific.
Mhm.
Having said that, what are the 3 to 5 criteria that you see most often in applications that are successful?
Absolutely. I think most people, especially if you are now at the stage in your professional career where you can apply for an EB-1A, you're number one going to submit for high salary. I think many of the applicants are making more than 70,000 or even $100,000 per year, right? USD. And so that's number one, high salary. The second one we really see often would be judging, judging the work of others in the field, and then authorship. People are published. People are, having publishing patents, and they're, writing papers, co-author. They're even writing books. So we really see those are the more commonly submitted app criteria that we see in successful applications. But again, as you correctly stated, it is very specific to each individual applicant.
Awesome. Hi, Anuva from SF. Nice to see you as well. What I'm going to do is I'm going to take some of Sid Mohan's questions, and then
Sure.
I have some questions as well. But
Perfect.
let's start with one he had, which is for an EB-1A01, what would be considered high salary for an electronics engineer in the Bay Area based upon your past experience or interactions? Is a 150K USD a year eligible?
So that opens the conversation, right? But when it comes to the high salary, USCIS really wants to see several things. Number one, compared to your geographic region, but also two, compared to other electronics engineers within your company. So what I ask my clients to do, if I can just give a little heads up, is to not only provide your pay stubs or your W-2 statements, but also a letter from HR confirming that you are receiving a high salary as compared to others. Some companies have been very amenable in providing my clients with those letters. So you might have some pushback, but that's also a key factor to provide. Now, I would have to confirm with your zip code about that specific number, but it's pretty high. Also, look at not just your base salary, but total compensation. Some clients are able to receive equity in the company or bonuses, performance bonuses. So look at total compensation as well. Just make sure that when you're submitting your documents, everything lines up, that what's on your W-2 statement corroborates with your pay stubs and also corroborates with the letter that you receive from HR confirming your employment as well.
That's very interesting. I think a few years back when I was applying for or trying to see if my lawyer would file an EB-1
Mhm.
petition for me, that time I was focusing on just EB-1B. I was actually told that sometimes a partnership in a company or a stake in the company was not looked at favorably.
Mhm.
But I know that now, having gotten more education about this and being kind of an entrepreneur in the automotive industry, I've got to learn from other people as well that profit sharing and equity within the company can actually benefit
Yes.
you and help you qualify for this criteria.
Absolutely, especially if there has been some valuation applied to that particular company. So now, we have a dollar, we can estimate a dollar amount as to what that stake is, then that would definitely help as well.
Awesome. A good segue into the next
Mhm.
question is that if this high salary or judging even are not applicable to a case, what would somebody do to kind of shore up some other criteria? Like what would those criteria would be, as you would suggest? I know you would need more information from them to get to that meat of that question. But let's take the average person that you have helped so far. What would you say the other criteria can come out?
Well, again, it is very specific to this person's, experience. What have they been doing thus far? If I can just interject here too, for the EB-1A, remember, it is backward looking. It is everything that you have already done and already accomplished in your professional career. So looking over the last 10 years, 15 years of your career, what have you done? Okay, what have you accomplished? So, were you ever published or co authored a book or an article? Have you submitted articles that were published on a tech or engineering website? And that, and your name is there. Were you quoted in something? Because you've been providing a lot of experience and insights for your company that now they're quoting your work. And also too, because some people work with very large companies, and so they're not the face of that particular company, but the name of a project they worked on is now in the media, is now public. And so we can also get a letter from a supervisor or a boss confirming and corroborating that you did work on this particular project, and talk about your contributions in that project as well. So I would want to know like more about what you have done, to give a more detailed answer. But don't shortchange yourself. Just try to start gathering everything that you've done and proof. Not just recommendation letters, guys, but proof of what you've actually done. And that's how you start to build out the other categories that you can submit for.
And proof in this case is public media, or what would be good proof in a case like this?
So of course, for judging, definitely want the invitation email that you received. If you received any metrics or guidance as to what type of judging to provide for your comments, and then proof that you completed your judging work. Okay. If you are quoted in the media, or there's a profile piece about you, of course, the full link and the full article, but also make sure you start providing some sort of metrics to show that this is, or proof that this was a major media that you did publish in. So Business Insider, we want to have some information about Business Insider, and then some information about the number of subscribers, viewers, downloads, retweets, as well, to show that it has reached a large audience as well. For publications, a copy of the paper, where it was published as well, things of that nature. You want to be able to showcase that you have, that you're meeting these categories.
Impressive. So for each category, proof might mean something different.
Yes.
And you have to provide that, corroborate the claim that you're making that you are extraordinary ability and can qualify for that criteria.
Absolutely, because it's not just recommendation letters. I've seen some very ugly, to be honest, RFEs issued for clients who just wanted to be very recommendation letters heavy. But then the RFEs come back and they say, "Well, where's the proof that you did any of this?" Anyone can write a letter for you, but if you don't have the proof, the methodologies, the frameworks, that show you reduce costs by 30%, where is that in a document? That you have to be able to provide that as well. The EB1 is very heavily evidence focused.
Interesting. I think, Avalon, what you mentioned there, like some of the examples you gave as to how you can improve yourself in different criterias, really fit well with one of the questions that I had. And please validate that, or you can add whatever you would like, which is for an industry professional who is
Mhm.
maybe non-academic, they don't have papers, they
Yes.
don't have publications, what would classify as original contribution of major significance? What types of evidences work in that case? And I think some of them, like whether your project is being talked about, whether you are being talked about, apply to that. But if you would like to expand further.
Sure. And that's a great question too, because, I know a lot of our viewers are saying, I did some great things, but how do I prove it? Right. And so let's say, if number one, I love to ask my clients if they have proof that their frameworks, their methodologies, their tools, how their patents, if it was adopted by someone outside of their company, So let's say a competitor is now using something that you've designed, or it was adopted by an unrelated company, so even outside of your industry, perhaps, okay, and then show that what you did, if it was timestamped, that would be the best case scenario, was created before it came to market or before someone else was using it. That's great as well. If you can also provide those letters from a CFO, CTO, some type of board of directors correspondence that says, okay, well, here are some actual numbers. This system that John created enabled us to grow by $80 million. Or we were able to, if you're working in a bank, okay, we reduced fraud by 37% across our departments because of this particular project. Okay, that's great evidence as well. Proof, let's say that other teams within the organization are relying on the system you created and that you developed. Or even by extension, if they stopped using, maybe they don't even have the numbers per se, but if they stopped using a framework that you developed, that, it would cause great operational harm to the company or to the division. Regulatory standards or policy alignments. If your work has been adopted by the company, there are some people who have scientific backgrounds or work with pharmaceutical industries, and they're creating SOPs, or they're creating something that's being used specifically that has now been incorporated within the company. You can provide evidence as for that as well.
Okay, so to paraphrase what you are saying, you can provide evidence of your work being used either internally, externally by a competitor, or even externally outside of your industry. If you can somehow prove that what you worked on, the project or your specific part in the project, if it is transferable or
Yes.
it is shareable in some way, then that will apply for original contribution as well.
Absolutely, because some people really only focus on the three criteria or meeting at least three of the criteria, but they fail to pay very close attention to the second prong of an EB-1A, which is the final merits. And there have been quite an increase in RFEs focusing, and NOIDs as well, notice of intent to deny, focusing on the final merits. Because in order to prove or establish final merits, you must, number one, demonstrate that you have sustained a national or international acclaim, meaning that people know about you. You have a reputation. They've heard about you or the work that you're able to do. And by extension, number two, that you have risen to the top of your field. How else can you show this but by demonstrating that people outside of your company have heard about you? That's why I always tell my clients, go to these conferences, go to and speak to people, introduce yourself, don't be shy, because the more people know about you, the more likely you're able to obtain independent expert letters or testimonial letters, which can help, especially when it comes to final merits. Great question.
Awesome. You talked about RFEs. So let me
Yes.
ask you a question about that.
Mhm.
How do you handle RFEs where the officer claims that the work that you're showing as extraordinary is essentially routine for your role or for your industry? How do you handle that claim?
That's a good question too. And we're seeing that issue pop up quite a bit now with RFEs that are being issued. So the number one question, or the first step I advise people to do, is, well, go back to your supervisors or your bosses. Okay, yes, we have to establish that your work is not routine. That's the first thing. That it was so out of the box thinking, it was so different, it had never been done before, or furthermore, let's say there was a problem even within the industry outside of your initial company, and you identified a problem and now have either created a perfect fix for it, or you are now laying the groundwork to fix an issue. So really honing in on what this applicant is doing on a day-to-day basis, and then is making sure we provide the evidence to show it's not routine. I think what opens the door to that particular RFE is when people simply put their resume or a basic recommendation letter, but that doesn't go into specifics. And that's what now opens the door to additional questions being posed as to what exactly do you do, especially when you come to leading or critical roles. What's so special about your job?
So it almost sounds like you need evidence, and you also need to position that evidence in a way that almost informs the judge on the USCIS side, or the USCIS officer, as to why this is not routine, or something of extraordinary ability.
You're right. And how if we were in a consultation right now and we were speaking about leading on critical role, my comment to you would be, okay, we need a recommendation letter with, of course, the corroborating evidence that confirms you are so indispensable to your organization or the department that if you were not there, they couldn't do what they were doing. That's how I frame it. And so when I'm drafting those letters, we have to be able to position it that way, because otherwise they will come back and say, okay, your job as an electronics engineer is run of the mill. Everyone is doing that. It's so easy to do. No, we have to focus in on exactly how difficult it is to do such a job.
I think I'm going to take a step away from our normal line of questioning and go to EB2 NIW, because that
Mm.
almost is like um, a tutorial, or in a way a step 1A to kind of go to the step 2
Hmm.
with the EB1. So we have a couple of EP NIW questions.
Sure.
One is from Raman Subramaniam, uh, Manian, sorry if I mispronounced that. If we have NIW approval, can we use the NIW as a supporting case for EB1 criteria?
Unfortunately, no. So both of these are extraordinary ability type visas, but the EB-1A is backwards looking, as I mentioned at the beginning, and the EB-2 NIW is forward looking. So if you already had your green card, what would you do? And there's some underlying criterias and questions it's asking, the NIW asks, that doesn't line up as easily with the EB-1A. So, for example, the NIW asks for your proposed endeavor to have substantial merit and national importance. The EB-1A doesn't really ask for that. It's just looking at what you have already done. It's great if it's had an impact in your industry. If your industry can then touch or help America, great. But that's not really the focus. So it's congratulations if you do have an NIW approved, but it doesn't really fall neatly into one of the 10 enumerated criteria or the final merits argument at the end.
Interesting how you juxtapose EB1A as something that's looking back, and NIW as something that's looking forward from a
Mhm.
national interest point of view. It almost sounds like there are two different visas in a way, or two different routes to take,
Yes.
where even if, let's say, somebody's NIW gets rejected, that does not disqualify you from trying to go after the EB1A part.
Absolutely. The EB-1A, I think, is definitely the visa for more, let's say, seasoned professionals. Okay. You've been in your industry, even at multiple jobs, but in the industry for 7+ years, 7, 10,
Mm.
15, 20 years. I've seen some young people, just graduated with their master's degree, have successful NIW petitions as well, because it's all about this idea, this proposed
Yeah.
endeavor. And you don't have to submit anything to show your endeavor is actually going to work, or how you're actually going to get this done, and get a contract with the DOJ or what have you. But it's forward looking, and so they do go into different categories. They're not combined in any way.
Mm. I think related to NIW, um, Sid Mohan asks a question regarding the petition rejection rates being extremely high. Further to this, the processing times are increasing manifold as well. So, is it futile to file for a NIW I-140 till 2028?
So I your commenter says, the word rejection. I just want to make sure
Yeah.
that if a petition is rejected, that means USCIS has returned it to you because something was lacking. Most likely, a form was outdated, or a form was unsigned, or the filing fee did not go through. In that case, USCIS will reject the petition, send it back to you, and allow you to resubmit with the corrections made. But if you're speaking specifically about a denial, so they've received your petition, they took the money, they gave you a receipt notice, and now after RFE maybe or annoyed, you now receive a denial. That, I think that's what you're really asking, and I don't want people to mix up those two words. And yes, the rejection. I won't say they are extremely high, but yeah, I mean it's not an easy visa to have approved. Just because you have an idea or an proposed endeavor doesn't mean that maybe it has substantial merit to the United States of America. And so there are very different regulatory criteria that we must meet if you are applying for an NIW. I would not wait until 2028 to submit an application because they are adjudicated upon receipt, and then you also receive a receipt notice. And if you're from a country with really long wait times for an EB-2 visa, you may want an earlier priority date. A priority date for 2025 is much better than a priority date for in 2028.
Yeah, I think if I could kind of teach my fellow Indian born or even Chinese born immigrants this, which is it is not linear. The priority date versus the green card queue is
Yes,
not a linear relationship. It 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 is almost like an exponential curve because there are
yeah,
a lot more people that have applied for green cards post 2012. So if you think that the people in 2012 2013 are getting green cards right now, so that is like, okay, what is that? Oh, 12 14 years, okay, I'll get my in 12 14 years. That's not the case.
exactly.
You my joke is that I'll have grandchildren before I get my green card. That's my joke. So, if one, that's one thing. If I could kind of drum into people is that this is not a linear curve. So I'm glad you raised the point where a priority date with NIW being secured can actually reduce a lot of many years down the line.
Exactly. And we don't know what's going to happen with the priority dates and in the visa bulletins, how some months there's no movement. Some months, we jump ahead, 6 months or a year. So it just depends. It's always better to have an earlier priority date. So if you are qualified after speaking with an attorney, if you would like to, about assessing the chances of your visa, please apply.
Absolutely. What I'm going to ask you next, and probably also try to see if I can join the chat and add our link to it, because you talked about consulting with a lawyer, and I think what Manifest does amazingly is provide free consultation. So that is excellent. I know I would feel that to be excellent as a fellow immigrant. I'm going to switch back to EB-1A.
Sure.
And we were on rejection rates and approval rates. So there's one question about, can you provide what the current stats of approval rates are for the EB-1A?
So it has decreased a bit. The we're seeing with USAS an average of 70 to 75% approval rates now for EB-1A applications. But I will say this, don't think in your mind worst case scenario, oh, they're just rejecting every single case that comes through. No. Um, when you submit your initial petition, make sure you have a lot of the evidence that's needed. Um, every one of our viewers and listeners who will watch this later, you're all very intelligent, but just keep in mind that there's some nuances that you may miss when you're trying to draft a petition on your own that perhaps an attorney may not miss. And so, you want to have the best fighting chance. So just take time to don't rush to submit an application. Really take time to build it out so you're not applying, with a futile attempt for these particular visa categories.
So Again, I'm trying to paraphrase so that I can help others get
Absolutely.
takeaways as well, which is yes, the approval rates are lower than what they used to be, but that still does not disqualify you. I think the worst thing you can do is disqualify yourself.
Yes.
Have other people like give it your best shot and just see what happens. Because I have seen a lot of my friends get an EB-1A because they had the gumption to build a profile to kind of give it a shot, while a lot of us would have sat on the armchair and
Yeah,
not
yeah.
taken action. And sometimes you look back and say, "Oh, damn, my friend got an EB-1A.
Mhm.
Now you have that fire to kind of get started again." So I really like your take about having some drive, having some gumption to go for it if you can.
If you can, absolutely. That's why I always tell people now, some people from your first job 15 years ago, you may no longer be at that company. You may no longer have the evidence that the email saved or the PowerPoint presentations you created saved. But, don't allow that to disqualify you or from not even speaking with someone at with a consultation to assess your overall chances and your entire profile. Absolutely.
Awesome. One quick question regarding wages that Anua asks is, do wages at the time of STEM OPT affect high talent visa applications?
So the salary you receive, does it affect it negatively or positively? I would not say negatively. Now, of course, you don't want to include something if you were making $37,000 a year, right? You want to be sure that you're including something that would actually benefit. Now, if you were working with proper authorization, STEM OPT, it was a significant job in the same industry that you are currently pursuing or you're currently in, and it reaches that threshold where you are at the top 1%, 2% of the other people for that particular job, then absolutely, I don't see why you would not want to include it. But by talent visa, I just want to confirm if that person means for an O1 visa or an EB-1A visa.
I think at this point, if they are talking about STEM OPT, it might be more related to an O1 visa.
Yeah. So then I don't think though it would have a detrimental effect on your application.
Okay, nice. Let me go and see if I have a question that I can ask from here that applies to EB1A. When if we have time in the end, we can always take more questions about non EB1A as well. I'm just trying to stick to the topic here.
Perfect.
Here's a question. Can reference letters from early stage startup CEO stating volunteering contribution to raise funds and get projects be used to meet O1 or EB1A awards criteria? Startup is not employer and has no earnings yet.
That's a very good question. And I love reference and recommendation letters from companies that are relying on your work, whether you were an employee or not. Because now, for the EB-1A in particular, we're able to go back to that final merits category we were talking about and show that you have this acclaim. People are reaching out to you. You're actively being sought out for your contributions, for your insight, for your knowledge, your expertise. So I would definitely say if you're able to obtain such a recommendation letter or reference letter, please do so. Because it does sound like, and of course, it should be specific and detailed to exactly what you did contribute, even as a volunteer. I think that would help.
So it sounds like you are saying there's opportunity here, and maybe this person needs to talk a bit more with a immigration attorney to kind of figure out the specifics as to how to position that.
Yes, especially to know exactly what it is you did, that you contributed, and how they relied on your contributions, on your advice, for example, and how if there was a before and after, they were losing money, you came in and volunteered. Now they're in the green. Perfect. Let's include that in a recommendation letter. But it sounds good. I like it.
Awesome. So this is a good point where I can share like the link that you can use to kind of get a free consultation with the Manifest team. So I've been grateful to be one of the partners that Manifest partners with, and I'm not able to add the link in the chat. I don't want to risk joy connecting my YouTube right now and getting kicked out, but it's quite simple. So it's manifestlaw.com
Hmm.
/partner /Varun. So if you use that link, you will be able to request a consultation with the team, and you can talk about your specific profile. Thank you to the Manifest team for
Perfect.
adding that. Appreciate that. Use that link to get a free consultation, and you'll benefit from speaking to a lawyer about your specific uh, case. What I would like to ask the audience to do is to kind of add to chat any specific questions you have about EB-1A. I think we'll stick to that topic for the next 15 minutes or so, and probably in the last 10 minutes, we can open up to just other questions. One question I had, Avalon, about EB-1A criteria is something related to the leading role
Mhm.
criteria. Does it, do you require a high ranking title for it? Or how can you position yourself if you don't have that?
That's a great question. And the answer is no, because again, it's always going to come down to the evidence. So, what evidence do you have to demonstrate your role is leading or critical? So, for leading role, even if your title is not CTO or CFO or something with a chief title, or even with a director title in front of your name, let's look at your job description. What do you do? What are you responsible for? Do you have direct or indirect reports? Or maybe you don't have any reports, but your contributions are being used by other departments, and you have to oversee or work closely with other departments as well. But if, and what about hiring or firing, supervising new hirees, training, mentoring new people that come in? What type of activities are you responsible for? And then for critical role, if I can just add, for critical role, again, that goes back to the role, the nature of your position being so indispensable and necessary for your company. Are you the first person that created a new department? Were you the first hiree for that department? And you're now the one leading the charge, whether it's a pharmaceutical company you work for, a tech company, you work in the sports industry, whatever it is. Like, were you the first hire? Are you now leading? Are they relying on you and your insights when it comes to the direction that company will go? So, again, look at what you do on a day to day basis, and then let's assess after.
You've shared so many different ways to look at each of these different criterias.
Yeah.
Let's say if I'm somebody who has 10 years of experience or 7+ years of experience, like you
Hmm.
said, I know a little bit about each of these criterias. Now, I have the benefit of Avalon sharing that you can kind of look at it from a very different angles. Should my next step be? I mean, should I look at everything that I understand about my industry, about my role to judge whether I should take the next step? Or do you recommend somebody just speak to a lawyer at this point? What would your recommendation be?
Definitely speak to an attorney. One, because you need to assess the strength of each category, each criteria you meet, because you may think, oh, I definitely meet this particular membership category. And then you speak to an attorney who understands the current internal trends for USCIS and how they're looking and assessing memberships in certain associations. And that attorney says, actually, it would be better suited for you to put that membership in final merits, as in the overall presentation of who you are as an applicant, rather than a standalone criteria, because you don't want to open the door to a request for evidence unnecessarily. So you definitely need to speak to an attorney. Also, that attorney will be able to then properly guide you in how to fill in those gaps, if there are any gaps missing in your profile as well, what to add, who to speak to get another recommendation letter. I know we at Manifest, we provide the drafts of the recommendation letters because we understand the specific verbiage that or the trigger words, for example, that USCIS likes to see when it comes to these O1A or EB-1A recommendation letters. So yes, definitely, if you were my the potential clients, of course, speak, then I can properly guide you, especially on the types of evidence you need to really showcase what it is that you're doing.
I think that is excellent. What I can also come out of this meeting is that an attorney might say that there is a gap between where you are and where you need to be. When somebody hears that, how should they not get discouraged and kind of continue to still work towards this goal?
Well, if I know if you're speaking with any of our attorneys here, we are going to tell you, okay, well, you don't have any public, like any conferences under your belt, but you attend the conferences. So submit your profile to be one of the speakers. Submit one of your PowerPoints, papers, abstracts, so you can, present at one of these conferences. We will always give you or try to give you a step by steps of what to do next, or even to get you thinking, as you guys are the experts, right? You are the extraordinary individuals in your industry, at least to start like triggering your brain to start thinking, okay, well, oh, I can ask my professor. Those of you that have your masters, um, I hope you did well in school, that you can go back to your professors and say, hey, professor, what's out there? Give me some guidance, because professors always know what's going on when it comes to your industries and how best to position yourself as well. Also, when it comes to authorship, professors always know of opportunities for you to publish. Reach out to them as well. Like, we will have those kind of conversations when you are working with an experienced attorney.
That is excellent because not only do you get an understanding of whether your profile is ready or not, if it's not ready, it sounds like you're providing next steps or ways to kind of take action once they go out of this meeting with your team.
Absolutely.
All right. I see a question come in from Santosh Reddy, which is, will having an EB2 NIW help in the EB1A approval process? We've had this question come up before, and Avalon shared something that I'll just briefly share. Avalon, you can add or edit anything that
Mhm.
I'm sharing. But Santosh, what it looks like is the analogy that Avalon shared is EB1A is essentially looking back at how you've contributed to your industry and to your role, whereas EB2 NIW is a bit more forward facing as to what you will do for the national interests of the country. So it is a little bit of a disassociated visa and does not kind of help one or the other. I just thought I'll paraphrase what you were saying,
Absolutely.
Alma.
Yes, and that's absolutely correct. So it doesn't give you a leg up, unfortunately. Or they're not saying, oh, this person has an NIW, I'm going to look at them more favorably. That's not how it works.
Interesting. I do have one question, and we'll again open up to the audience. Is a lot of people nowadays are working in narrow niches. Let's
Mhm.
take the example of an automotive engineer. That's been my industry, so I have some insight about it. Let's say there's an electrical engineer just working on all the chargers that are in now at gas stations that charge battery technology. So that's a niche field within a niche of the automotive
Mhm.
industry. Do you in that case, when you define a field for this person in their application, do you define it as that niche and then how you are at the top of it, or do you broadly show national impact? Like how would you balance this to avoid a niche is too small to be significant denial?
No, that's a great question. So when it comes to niche fields, I focus and use that actually in my legal argument as a benefit. that there aren't people in this industry or in this niche field, and so we use that as an advantage as well in presenting and crafting your application. So I would not broaden it. So when it comes to science, technology, and the athletics, entertainment, business, of course we're going to focus on one of those and make sure your niche falls into one of those categories. But I would focus specifically on your niche area and the contributions to that you have made to that niche area, both for your company, secondly to the field at large, the niche field at large, and then when it becomes a final merit, specify that there aren't many people who can do what you do. That's why it's so niche, and that is what makes you extraordinary. So it's all about positioning, but I would not put it as into a broader field.
Awesome. So it's a strength that you should bolster in this application.
Absolutely. For niche industries, yeah, because now your petition is different. You're not, one of 500, you know, librarians that they have like read a petition for every day, right? Like this is something so different. So now their interest is piqued.
Awesome. Dr. Bernard asks, I think I have at least three criteria. How do I know if I'm eligible to apply?
So, I mean, I think at that point that if you're not sure and you're straddling a fence, then you would need to speak with someone who is qualified, who's experienced, to then really assess your profile in detail. Please have your resume ready for them to look at, any Google Scholar links perhaps that you're ready to provide as well, so that, an attorney can really assess where you are, and potential chances and also potential gaps in our consultations.
Awesome. So it sounds like you have the opportunity to talk to an immigration attorney, talk to them to kind of understand whether you qualify or not, what is the strength of your profile,
Mhm.
and whether there are any gaps. Like I was just talking to Avalon, and she mentioned that even when the team notices a gap, they actually go forward and kind of share some next steps and how different ways to look at that. And Dr. Bernard, you'll find a link right on the screen here, manifestlaw.com/partner/Varun. I've been grateful to partner up with them where they will give you a free consultation. You just have to request that and you can share your profile with them. I think that would be a great next step for you.
Absolutely, because ultimately you want to make sure every category you are submitting for, you meet strongly. If you don't meet it strongly, if, for example, you were only quoted in one article, maybe it was even on CNN, but if it's only one, you may not want to include that as one of the categories or criteria you're submitting for. Okay, so at that point, this is how you now know that you may need to speak with an attorney to really go through and assess the number and the quality of each of your evidences and your experience.
Awesome. I think we did have a few questions, not regarding EB-1A.
Okay.
If anybody has any questions regarding EB-1A, please chime into the chat. What I would ask as a final question, Avalon, is there anything that we haven't talked about today that you think is important to know from a criteria lens?
We did touch on it at the beginning, but if I can just focus again on the final merits. Um, Firstly, you should not reuse evidence for multiple criteria. Okay, the government as of USAS as of now, they're looking at that very unfavorably. So make sure every evidence criteria has its own set of evidences. Okay, so if you publish an article on CNN, and now you're using that as media, press and media coverage, and as your authorship category, it's not going to have the same weight. So just be careful when you're trying to categorize your evidence. But also, secondly, when it comes to your final merits, again, who knows about you outside of your field? Outside of your company, because I've seen requests for evidences where the USCIS will admit and agree with you. Yeah, yes, you are making incredible contributions to your company or to your department, but who knows about you outside of the four walls that you work on within day to day? And that's what people really have to to provide evidence for, because they can agree with you that you meet those 3 criteria or even 4 criteria. But if you fail at final merits, then you're going to either receive a NOID, an RFE, or a denial. So do not overlook the importance to submitting enough evidence for final merits.
That's awesome. That's an amazing takeaway. I see a question come in by L.Y. Sani. I'll stick to that name. How do you know the best route to go for between EB-1A or EB-2 NIW? Still on OPT and building a profile, but working in the affordable housing space.
That's excellent. But I will say, you are still on OPT, so you have really yet to do much work, at least in America, for your career. So perhaps because not every 25-year-olds are on OPT, you have some people who came to America later on in their career and they started over, for example, but they may have had a professional experience across in the home country or in another country. So number one, have you done anything abroad? We can also look at your international experience and assess what you've done internationally as it pertains to these visas. But assuming that you are in the beginning stages of your career, as I mentioned before, you're going to be more suited to applying for an NIW petition because you don't have the 7+ years of experience already in your professional career. And I will just say, for affordable housing space, that sounds like an area that America will care about. It has substantial merit. We have a housing crisis. We have a homelessness crisis in America. And so to be able to provide and craft a proposed endeavor that would touch on this particular area would be persuasive. Would it sound like it would be persuasive? And at Manifest 2, we also help our clients in crafting compelling proposed endeavor statements. So it does make the officers think about what it is that you're doing. From this one comment, I think you're leaning more toward NIW, but again, further conversation with an attorney would be warranted.
Yeah, and it's excellent that you are thinking about profile building on an OPT. I
Yes.
was somebody who had complete immigration blinders on,
Yeah.
so it's awesome that you are thinking about at this stage, and a conversation like this would be really helpful for you. So I would highly recommend getting in touch with the lawyers at attorneys at Manifest.
Absolutely,
I'll
because it's
take up.
now just one more now too.
Yeah.
If your ultimate goal, because EB-1A does have shorter wait times when it comes to the priority date. So if you can start now, like you said, and then saving the work that you're doing when you're working in these different companies, of course that's not proprietary or confidential, and generating or creating the relationships with your bosses, so that they can write you those strong recommendation letters 5 years out, 7 years out, 10 years out. That's great to do as well. So if you can't really compose a proposed endeavor statement and you're just thinking long term, 5 years from now, 10 years from now, then definitely, absolutely build a profile so you have that demonstrated proof of a sustained career in your industry.
Awesome. I think this will be the final question, and then I want to give people an opportunity to share what their biggest insights were from this chat, because I think you shared amazing information, and I want to give them the opportunity to kind of share what their highlights were. The final question is by Sid Mohan. The NIW I-140 petition rejection rates are high. Uh, oh no, I think we've already covered that. One
Yeah.
second, my apologies. Right, so NIW I-140 has been pending since the last 13 months. What would you suggest at this time? Should they file a premium, which might lead to an RFE, as the officers might be reading the petition, not reading the petition carefully?
So unfortunately, the regularly filed petitions are taking a very long time. And if you've been waiting 13 months and you do nothing, I think you could safely expect to wait about 4 to 5 more months before any decision is made. Um, so that's something to keep in mind too. Do you need a decision sooner rather than later? But I just want to just clarify this one misconception people often have when it comes to premium processing. It is not going to increase the chance of receiving an RFE or a NOID. Yes, the officers must make a decision in 15 business days. However, there's still the likelihood if an RFE is issued from the premium processing unit that you may still have gotten an RFE if you had continued on the regular processing timeline. So don't let that be a determining factor as to whether or not you're going to submit for premium processing to obtain a decision faster. It really just comes down to your current status, and if you're just tired of waiting. But 13 months, you're still within the normal window for an IW to be adjudicated, unfortunately.
Interesting. I know processing times kind of go faster, sometimes they go slower. It has an impact on people's life and emotions, but you have to take all of that into account now as part of your immigrant journey in the US. So, interesting point there. I will ask everybody who were present in this chat, please share your top takeaway or a top insight. I think Avalon has given us her time and expertise, and I would love to see some comments back as to what you benefited from in this session. Avalon, from my personal point of view, I'll share a couple big takeaways. I think one, you mentioning how, as a team of attorneys, you are actually trying to help people close that gap. So, not only review the strength of somebody's profile, but actually advise them on what their next step should be, I think is really a big advantage to somebody who's looking to build a profile
Yes.
and looking to understand from a credible voice what that looks like. So,
Hmm.
really love that takeaway. The other takeaway is that there is some creativity involved in this
Yes.
entire process
Hmm.
where you have to look at your candidature, you have to look at the work that you have done, the relationships you have built, and with the help of, again, a credible source, somebody who is an expert at this, kind of build your profile, position your profile in a way that can get an approval and get you to that faster green card so that you have more immigration stability, you have more career mobility, because a lot of times career mobility gets impacted as well. So thank you for sharing all these amazing insights. I see Dr. Bernard saying thank you. I would love to see an insight or two or a takeaway or two that people have had from this chat. Any final words for us while I see if we have some people chiming in?
Sure. Again, don't count yourself out because you're looking at this visa journey and this immigration journey from, a personal perspective, and sometimes you're not looking at things as you should, that a lawyer would, an attorney would, from a professional, hands-off approach. So allow someone to really look through your profile, your resume, and assess it, so we can really better determine where you stand today and if you need 6 more months to build out your profile and fill in those gaps. If you need a year, don't just write yourself off and think, oh, the administration is too hard. I heard our fees are increasing, denial letters are increasing. No, talk to someone. Don't try to file on your own. If you can, really work with an attorney, because we know and we're positioned to properly craft and be creative, but craft that application that has the strongest chance of approval.
Awesome. I don't see any takeaways here, but I do see a few other people saying thank you in the chat. I know Santosh Reddy, thank you for your responses. I also see Rama Subramanian, thank you for your responses as well. Let me end this chat with a fun question. You said you are from the Caribbean islands.
Yes.
Any experience with cricket, either watching it, playing it, any experience with cricket?
I actually don't. I know this is embarrassing, right? But no, I don't. I watch it, but I have never played. I don't even know where to start in learning how to play cricket, but I do watch it.
That's very cool. That's very cool. That's one thing that joins a lot of different Commonwealth countries, that sport. Pretty cool to kind of know that. I do see. Yeah, Santosh saying thank you for arranging this session. I've been thinking recently to explore the option of the EB-1A process. I do have pretty good work experience, but I'm hesitating to file for EB-1A. I think I'll just double click on what you've said earlier, is that don't count yourself out of this process. It
Hmm.
is a communication game, it is a positioning game, it is
Yes.
a way for you to kind of prove that you have good work experience. I have heard my friends in fact say that it helps them with their career because they've taken so much time to think about the
Hmm.
impact that they have created in their workplace. So I would highly recommend Santosh in this case to talk to immigration attorneys. A final call to action would be the link that you see on the screen. You can
Okay.
use that to request a consultation. So I would highly encourage that. And thank you so much, Avalon, for this amazing session. And hope to bump into you in the future in person.
Yes, thank you so much for having me again. It was truly a pleasure, and you had some great questions. I enjoyed my time here. Thank you again.
Thank you.